Hello everyone. In this segment, we discuss doctrine of ultrawires. The term ultrawires is derived from the Latin word meaning beyond the powers of. Any transaction or activities beyond the scope of the company or the authority endowed upon the custodian of the company will come under the scope of doctrine of ultrawires and can be criticized accordingly. The concept of doctrine of ultrawires was first introduced in the United Kingdom in 1612. The concept of doctrine of ultrawires enables the man to determine whether the action is legitimate or illegitimate. The concept has been elaborated by the judges in various judgments over a given period. In the case of Sultan Hospital of the Year, it was stated that the doctrine of ultrawires will not be applied for any action or transaction of chartered accountant, even though such corporations are corporate personalities with a separate and distinct identity. What is the purpose of doctrine of ultrawires? The doctrine of ultrawires is introduced to safeguard the creditors and investors of the company. The doctrine of ultrawires prevents the company from using the money of the investors other than those mentioned in the object clause of the memorandum. Both the investors and company must be assured that their investment will not be used for the object or activities which they do not have specified at the time of investing money in the company. This ensures that the funds of the investors won't be dispersed in unauthorized activities by the company. The wrongful use of company's assets may result in the insolvency of the company, a situation where the creditors of the company are not being paid. The doctrine of the company prevents the wrongful use of the company's assets, thereby protecting the creditors. Also, the doctrine of ultrawires prevents directors from diverting the project for which the company has been formed out, and hence constantly examining the activities of the directors. It helps the directors to know within what lines of business they are eligible to act. Scope of doctrine of ultrawires. The doctrine of ultrawires applies only to those companies that have been incorporated or have a separate existence in the eyes of law. All those companies that have not been registered, such as sole proprietorship or partnership, will not fall under the scope of doctrine of ultrawires. Only the companies that are incorporated or have a separate existence in the eyes of law comes under the scope of doctrine of ultrawires. Every illegal transaction or abuse of power by directors or employees of a company will not come under the scope of the doctrine of ultrawires. Only the transactions that are beyond the scope of what a company can do will be liable under the scope of doctrine of ultrawires. What a company can do or the purchase of those companies always mentioned in the object clause of the memorandum of association of the company. If the company is exceeding the authority it has mentioned itself in the object clause of the memorandum of association will be criticized under this doctrine. Exceptions to the doctrine of ultrawires. Firstly, any act which is within the scope of the object clause of the company but outside the authorities of the directors can be authorized by the directors. The shareholders retain the authority to approve an ultrawires act performed in an irregular way in the company. If the company acquires any property using an ultrawire investment, even then the company's right over that property can be defended. Any incidental or serious effects of an act shall not be considered as ultrawires unless it is expressly prohibited by the statute. Okay guys, that's all for today.